Hi everyone, and welcome to today's webinar, Accessing the National Disability Insurance Agency, NDIS in Queensland. My name is Catherine Bowden and I'm the Communication and Community Legal Education Officer here at Legal Aid Queensland. And sitting next to me is Loretta Crete. Loretta is in the Civil Justice team here at Legal Aid, and she'll be going through the presentation after a few housekeeping slides. Okay, just letting you know that today's webinar is for community legal education purposes only. And I'd like to start by acknowledging the traditional owners of the land on which we meet today and pay our respects to elders past, present and emerging. All right, so you know the webinar will be recorded. You'll be able to access this on our YouTube channel at a later date. You can find our YouTube channel through the Information for Community Workers and Carers page on Legal Aid Queensland's website. If you are having any technical difficulties, help is available on 1800 136 402. If you'd like to go ahead and download the handouts today, that would be great. We've got three here for you today. We've got the presentation slides, we've got the decision trees, which were emailed out the other day, and we've also got some contact details for community workers like yourselves only, not for clients, please. Okay, if you have any questions, you're welcome to submit them as we go along, but we'll be holding most of those until the end. We have received quite a few questions before the webinar started, and that was great. So Loretta's going to weave a few of those into her presentation slide.
I hope so, yeah.
And anything else we don't get to, we can cover at the end as well. Okay, let's start with a poll. So those who have attended our webinars before will know we usually like to know what area you work in, just to help guide the webinar today. Are you from Southeast Queensland, Far North Queensland, Regional Queensland, or outside of Queensland? So far most of you are from Southeast. Doesn't look like we have anyone from outside of Queensland today, although I know there were a couple of you registered. So Loretta might touch on whether the law applies or doesn't apply for those of you who are from outside of Queensland. Okay, so there you go, half of you from Southeast Queensland, and we've got quite a few from Far North and Regional, which is wonderful to see. And one more poll before I hand over to Loretta. How would you rate your knowledge of NDIS, the National Disability Insurance Scheme? I know you're all here to learn a lot more today, which is great. And this will just help Loretta understand how much knowledge you already have. And hopefully you've had a chance to read the decision trees, because that's going to guide the presentation today. So if you haven't, make sure you download that before Loretta starts. That's called NDIS Decision Tree Process under the Handouts section. Okay, I'll share the results with you if you're interested. So a lot of you have a good and limited knowledge. Quite a few have a high knowledge of NDIS, and I'm sure you'll all learn a lot today. Okay, so I'm going to pass over to Loretta, Senior Lawyer in the Civil Justice Services team.
Thanks, Catherine.
No worries.
So I'm going to start by saying that I'm not going to talk a lot about the decision trees, in fact, Catherine, so you can just use them for later on. But the one that we will touch on a little bit is the one about getting access to the NDIS. And what's important is that, well, this presentation is all about getting access to the NDIS because, and the reason why we chose this as a topic is because more and more matters are coming before the Administrative Appeals Tribunal where the participant has been refused access to the NDIS. So what we'll cover today is how to get help from legal aid, how to apply for access or applying for access or early intervention, the differences, when access is refused, how you can get a successful review, addressing the criteria that you need to get access, and also the questions that have been asked. So the reason why we chose access in particular was, like I said, there's been an increase in the number of people that have been refused access across the state. And the common issues include, does the person have a disability or is it a health condition? And if it is a disability, is the person, the impairments resulting in a substantially reduced functional impairment in a number of areas such as learning, communication, mobility, etc. And will the person require the NDIS for a lifetime? So they're the ones that are mostly coming up to us in terms of getting access under the disability requirements. If you want to get access, you can also get access for early intervention. They're called the early intervention requirements under Section 25. And in there, we also see, does the person have a disability? If you do get early intervention, is it going to assist you to in terms of your future needs of the NDIS? And the issue in early intervention there is, will another system of general support, is that more appropriate rather than the NDIS? Thank you. So one of the things that I found out when Catherine sent me the questions is that some people may just have a very limited idea, not only about the NDIS, but also about our role, Legal Aid Queensland's role. And so I just wanted to go a little bit through that, both for your sake and also for the clients that you might be supporting. So one of the things that Legal Aid is, we're lawyers independent of government and the NDIA. So when a person comes to us for legal advice, it's similar to them going to a private lawyer, but in fact we even have more privacy requirements than those generally for private practitioners, because we are also covered by the Legal Aid Act, which is very important because any information that you provide to us, we are not able to give that information to the NDIA without your permission, or to any other government departments, because it's like you're getting private legal advice. So we can't control what the NDIA does or what their policies might be in respect of certain supports, or the delays that or the delays in making plans or doing internal reviews. All we can tell you is about the decisions that the NDIA makes, how you might go about appealing to those. So that what I wanted to touch a little bit to you is how you can access advice for you and your clients, and also how to access legal representation when you or the clients are unhappy with the decisions that have been made under the legislation. So because we've got a little bit, we're provided with a little bit of funding to go and do this work, we've decided to not only give legal representation for reviews, but also to give advice, because we felt that that was an area where, especially at the beginning, people don't know how to go through the process, but not only how to go through the process, whether there's merit in going through the process, or whether they need more information, or the law isn't going to support their application to review the matter. So we give at the moment 2 advice clinics. One is on a Wednesday, which is an in-house clinic at Legal Aid. It's only available to people who have already gone through internal review, or are in the internal review stage, or are making an application to the AAT. The other advice clinic that we run is one on Fridays, which we actually run from the AAT, and the AAT, that's the Administrative Appeals Tribunal, actually books those clients in. And the reason why it's so good that we get to do a clinic from the AAT is because, as lawyers, we need documents. Very difficult for us to give advice without documents. So the AAT provides us with all their files as to what material has already been lodged with the AAT. Okay, where people have come to us, and they're not, don't have a plan, or are thinking of appealing the decision internally, we'll either refer them to the local area coordinators, or we'll send them to a disability advocate who they have been funded to help people through the whole process. We are only funded to provide assistance in specific cases. Right, no, stay there. Okay. So the assistance available for reviews, like I just mentioned, there's two organisations really, well, more organisations in the first one, and the second tier, only one organisation, Legal Aid. So the NDIS appeals advocates provide assistance to people for reviews. Like, you can just read it on the slides. They're non-government organisations. They're specifically identified by the department to provide support once the plan is in place. They also help with applications for legal representation. Okay, keep going. So the legal assistance available for reviews is that provided by Legal Aid Queensland. So when you come to Legal Aid Queensland, generally, if you wanted to make an application for funding on any matter, you would have to both meet a means and merits test to get legal aid. In these matters, we do not apply a means test. So it doesn't matter as to the capacity of the family, their child, or the capacity of the or of any of the person themselves or any family members as to whether they would get legal aid or not. It's all based on the merits test. And the merits test is not only is legal aid's general merits, but also special tests that our funder has provided, that we can only provide assistance if the matter is novel and complex. Now, what we mean by novel and complex is not that the client is complex. So, you know, one of the things that we have thought about and struggled with, or that you would probably be struggling with, what about all those people, and we know that a lot of people who are accessing the NDIS either have an intellectual impairment or a mental health issue. That does not make their matter novel or complex, because it's not about the capacity of the person to access, it's whether their matter is complex. So is it a question of law that hasn't been determined? Will it change the way that the NDIS administers the scheme? Those sorts of things can come into the issue of whether the matter is novel or complex. But we also apply some other tests as well, which is the appropriate use of public funds, the prudent litigant test, and the prospects of success. And so one of the things that I just wanted to touch a little bit on is the prudent litigant test. So somebody might come to us and say, we want this particular support, we think it's reasonable and necessary. The support costs $500. The cost of us running the case would be $3,000 or $4,000. That would not meet our prudent litigant test, because you yourself wouldn't fund a lawyer to get services for $500 when it was going to cost you $4,000 to do it. And of course, that means also that during the course of the matter, if we get a medical report and determine that no longer the person has merit, so we might get a medical report that says, well, there's not a reduced functional capacity, a substantially reduced functional capacity in any of the areas, therefore we're not going to, it would no longer meet the prospects of success test if the argument was about access to the scheme. Thank you.
Okay, I'm going to go for a quick poll here. Third poll of the day. Are all decisions under the NDIS reviewable? Yes or no? We've got some very mixed results here, and Loretta's about to touch on this in the next slide in a moment. Just take a good guess. Still a few more of you getting your answers through, and then we'll close it off. Okay. The majority of you have said yes, still a good portion have said no. So I might hand back to Loretta and she'll touch on this.
I was going to get Catherine to ask this question after I gave you the next slide, because not all decisions of the NDIA are reviewable. So there's a list of the decisions that are reviewable in section 99, and I might touch on some of the matters that are not reviewable and why that's caused some issues, particularly around plan development and delays in plan development, and what happens when the NDIA doesn't make a decision. So, but so there's a list in section 99 of the NDIS as to the decisions that are reviewable. And if you have a look, if you do get a chance to have a look at the decision trees, in some of the decision trees, particularly, we actually touch on decisions that are not reviewable, and you'll be able to see when you go through some of the access one, or particularly the review of the plan under section 48, where a decision that the NDIA makes is not reviewable. But the sort of matters that mostly come to us are access to the NDIS, which is reviewable, the actual supports in the plan, and the review of the plan. But again, this webinar is directed towards access. So next slide. So becoming a participant, you can you first have to make an access request. That's section 19. That can be made at any time unless subject of a current internal review or an external review to the AAT. Why is that important? Well, we had a matter where the person had made a number of access requests to the NDIA and had been refused each time. On a subsequent access request, the NDIA had indicated to them that they needed to go through the internal review process and the external review process. And we don't agree with that, because it's quite clear that you can make a request at any time unless you're in that process. Now, what would be the utility of doing that is, I suppose, the question. If you're going to make multiple access requests, you're certainly not going to get anywhere unless you're providing new information or updated information. However, if you do go through an internal and external process and it's refused, I would say you're likely to get the same result if you don't have any new information the next time you go. But this is a particularly useful section because you might have a degenerative condition, which means that at one stage you don't meet the criteria about substantially reduced functional capacity in a specified area. But 12 months down the track, when your condition has got worse, you may very well be able to meet that criteria. So you do want to have the opportunity of making another access request. So in the particular case that we were taught, sometimes people are scared to go through the internal and external review process because they think if they've gone through the external review process and it's been refused, they're not going to be able to go back again and ask for it again. So then you have to meet the access request, and that is section 21 of the legislation, and you meet the access criteria if you have to meet age requirements, a residence requirements, a disability requirement under section 24, or the early intervention requirements under section 25. You can also meet the access requirements if you are receiving supports of a kind that's specified in the rule before the NDIS is rolled out. Now, this is where this does not apply in Queensland. This only applies, I've looked at the rules, it only applies in New South Wales and WA, where there's been rules made about them. And in those states, sometimes even if you were receiving Commonwealth supports that might have been available in Queensland, you would not get access to the scheme, but you might get access to the scheme in New South Wales using that section. So I would get advice about that. Let's just go back one more time. So the other thing is that if the NDIA doesn't make the decision about an access request within 21 days, they're deemed to have made a decision to refuse access. Now, that's conditional, though, upon them not having made a further request for information. So it might be the case for some of these matters where the access request has been going on for some time, that you might be able to argue that there is a decision that you can go and appeal to the AAT with. You really want to get advice about that before you go. So the access requirements are, you have to meet the age requirement, the residence requirement, the disability requirement, or the early intervention requirements. There's also rules relating to disability and early intervention requirements. So let's go on to age.
Oh, sorry, we're going to do a quick poll before we get to age. Unless you want us to come back to the poll at the end.
No, it's good if that it gives me an idea.
Gives you an idea. Yeah, just trying to have an idea of how much knowledge you have, for how much detail the reader should go into for the next slide. So Taylor is 62 when his access request is made. Taylor will meet the age requirement for the NDIS, true or false. Results are pretty swayed in one direction at this stage, but take a guess and we'll cover this in a minute. There's still a few more votes coming through. Okay, might close that off there. So the majority of you said that Taylor will meet the age requirement for the NDIS at 62 years old. And I'll pass back to Loretta and she'll cover this now with age requirements.
It is true that the person must be under 65 when the request is made. Now, I know that there are some issues. I'd be interested to find out of the people who thought it was false, why they have that opinion. Why they have that opinion, because the legislation is pretty clear, but I do know that there was some policy around maybe Indigenous people, but I'm not 100% sure about that, on that point. But the legislation is really clear. A person must be under 65 when the access request is made. Now, why that is important is that if you've got somebody close to 65, you really want to get them, well, you really want to make a decision, or the person really wants to make a decision about whether they should be looking to get services under the aged care sector or under the NDIS. One of the reasons why people may want to access the NDIS is because the supports that are available are often more than what you can get under the aged care, and there's often not a means test involved that may be applicable in the aged care sector. It doesn't matter when you obtain the disability. So I've just had a query just recently where the person is saying, well, I acquired my disability, when I was under 65. I'm now over 65. The support that I'm requiring is traceable, or is because of my disability. It's irrelevant. It's not about when you acquire the disability, it's when you make the access request. The second thing is that you have to meet the residency requirements, and those are, well, you can see what they are, about residing in Australia and the basis of your residency. And there's some rules about what makes you reside in Australia. So it's not as strict as, with some pensions. If you go overseas for more than a month, you'll have your pension, you could have your DSP restricted or whatever. It's not the same in relation, or, whether you're living here. There's all sorts of issues that they take into account. However, And similarly with the basis of your residency, so you have to be a citizen, a permanent residence, or protected special category visa holder, which there are some rules about what makes you a protected special category visa holder. It's not just a special category visa holder, which reminds me of the question that I was asked about. There was one question that was asked, refugees and limited English, the question was about refugees and people with limited English getting access to support to make the access request. And I think one of the issues in relation to that is that the first thing that you would need to consider for those people is, would they meet the residency requirements as to the basis of their residency? Yes, again, just because somebody is from a non-English speaking background or is a refugee would not mean that they could meet the novel and complex criteria for getting legal representation if they were to go to the AAT. That would not make their matter novel or complex of itself. So it's really, that would be the question that I'd be asking. And of course, it also means it still has a requirement that you have to be in the rollout area. And I understand that Gympie and Caboolture Strathpine are the last areas to roll out in Queensland, but they'll be coming online in January of next year. All right, we're on to, yes.
And there's one more after this one to go during the presentation. So Rachel's doctor looked at her substantially reduced functional capacity. What did her doctor consider? Did her doctor consider social interaction, learning, mobility, self-care, or did her doctor consider all of the above and more? So everyone seems to be spot on with this answer today. Okay, I might share those now because it's gone in a quite a clear direction. So 94% of you said all of the above and more. Pass back to Loretta to move through these in more detail.
So I will talk to you about substantially reduced functional capacity, not substantially reduced functional impairment, as I've put there. But I would have to say that the doctors should consider all of the areas above and more. However, not all of them need apply. You need to have substantially reduced functional capacity in one of those areas to be able to get access to the scheme. So to get access to the scheme, once you've met the age, residency requirements, you can get it in two ways. The disability requirements in Section 24 or the early intervention requirements in Section 25. So if you want to meet it's really important, can I just cut across here? It's really important that you look at the legislation, the rules, and then you look at the National Disability Insurance Agency guidelines. The guidelines will not be followed by the Administrative Appeals Tribunal where there is a conflict with the legislation and rules. They will consider them if there's no conflict. So one of the things that people have been going, well, the operational guidelines say this. We always go to the legislation and rules first. If they're not in conflict, yes, the AAT will follow them unless there's a compelling reason not to do so. So that's the first thing. So the disability requirements is you have to have a disability that is attributable to one or more intellectual, cognitive, neurological, sensory or physical impairments. And those impairments are likely to be permanent. The impairments have to result in a substantially reduced functional capacity in one or more of the following activities. And there's 6 of them. I'm sure that, look, social interaction is one, communication is another, learning, mobility, self-care and self-management. the impairments have to affect the person's capacity for social and economic participation, and the person needs the requires support under the National Disability Scheme for a lifetime. You have to remember that the participant must meet all of those, not just some of them. Disability, the disability requirement in and of itself is not often used as a means of saying you can't meet the requirements of Section 24. So having a disability seems to be a low bar, except where it's a health condition, and I might go through that in a little bit. The issue seems to be about whether it's permanent. It's the permanency of the disability that the NDIS seems to take most exception to. So for access to the NDIS, an impairment will be considered permanent only if there are known, available or appropriate evidence-based clinical, medical or other treatments. You should have a look at Rule 5.4 as well in the rules as to what that means. That brings me to a couple of questions that I was asked in relation to mental health, and I might just go and ask those questions now because I think that this probably relates a little bit to the permanency question. So the first question I was asked was, people with a mental illness are more likely to be rejected by the NDIS because their disability is not visible. Is that true? Now, I don't think that's true, but what we see is that the issue is not about the diagnosis, it's more about whether it meets the permanency requirements. And the issue for mental health seems to be whether the person has accessed all known available clinical, medical or other treatments likely to remedy the impairment. Now, that's a question for the evidence, and sometimes that's exactly what the doctor will need to say. This person has this impairment, it's permanent, they have accessed all known medical treatments. The issue though often is with mental health, mental health issues, it's that sometimes people won't access those treatments, but that would be a question of evidence as to whether they could still meet the disability requirements, but it would certainly make it it certainly makes it difficult to meet that requirement. The other thing that was asked, and this is probably, well, I might as well go into it now as well, is that the second question that was asked is forensic advocacy for the most vulnerable and secure mental health units, plus gender and culture matching support staff for services. What are the pros and cons? I suspect in relation to mental health units and gaining access to the NDIS, it's probably not a question of the pros and cons of the NDIS. Rather, it's a question is, are the supports going in those mental health units? And if so, will the person gain access to the NDIS? And having gained access, will the supports that they're asking for be seen as reasonable and necessary? So I don't think I can say anything more about that question. All right, so the next thing is you have to be able to show a substantially reduced functional impairment in one of those areas. So you can't say, well, I've got a reduced functional impairment in learning, social interaction and communication in all three, and together they make a substantially reduced functional capacity. You have to be able to show that in one of those that you would meet that test of substantially reduced functional capacity. Here again, it's really useful to have a look at Rule 5.8 in the rules. I never go anywhere without my rules or my legislation. And I think that's really important to remember for yourselves, that when you're looking at whether the person could possibly have access, where the person has access. Look, I've just had a question, and that question is something that we have looked at, and I would suggest that you get advice about it. Is someone who has a disability where there's available treatment, but the treatment is risky? It's something that you would need advice about, and we did settle a matter where there was an issue about whether there was surgery available, and there were risks associated with them, and they were seen as unacceptable risks. That matter did not go to a hearing. So I do think it will depend on the medical evidence in those cases. All right, now the other issue that then often the NDIA raises is, will the person require the support for a lifetime? Now, this is where the NDIA often argues that if the impairments come from what they see as a health condition, they may argue that because the person should be getting that support from the health system, for example, they do not require the support of the NDIS for a lifetime. And the NDIA argue, there was a case of Mulligan and the National Disability Insurance Agency decided in 2015. NDIA argue that this stands for that proposition that you can use whether you need to go off to the health system to deny a person access to the NDIS under Section 24. We don't agree with that, because we say, and there's support in that case for that, that this question about whether the supports that a person is asking for is more appropriately funded by someone else is a question that needs to be addressed once you're in the scheme, and when you're asking for the supports that you think are reasonable and necessary. Okay. However, in the early intervention requirements, these are a little bit different to the requirements to get in under Section 24. In there, again, there's a question about the disability and whether it's likely to be permanent. If you are a child under 6 with developmental delay, you don't need to, you can get in. You need to be able to show that getting in will reduce the need for future support, and that you will be, and that the support will benefit you by mitigating, preventing, or the deterioration of your functional capacity, improving your functional capacity, or strengthening support networks. However, you see in here you don't have to show a substantially reduced functional capacity, but what you do have to show here is that it's most appropriately funded by the NDIS. So if you have here, they can argue that that you shouldn't get in under early intervention requirements because what you're asking for, the support that you're asking for, is most appropriately funded, say, by health. All right. Who has typically been engaging legal aid for participate themselves, carer, or social worker? Well, until recently, when we took over the grants process for, assessing grants of aid, all of the requests came through the disability advocates. Now, though, because we're running the clinics in the AAT, and also we have the phone advice clinic, people can themselves come, but generally a lot of them are still coming through the disability advocates working in the field. All right. Now, one of the things that I would have to stress is that generally, if you want to get in for access, the evidence that you provide is critical. And particularly the medical evidence, and this is a problem with the access request form, because the access request form does not actually ask the doctor to say how the impairment is impacting on the person's functional capacity. It doesn't get to the root of that. So it's really important that the medical evidence addresses all the criteria in section 24 and 25. When we're giving advice, we do provide people with some draft letters that they can send to their doctors as part of the advice as to what should be in the report to support their request. It's really important that it's that the report covers all of them, because that's where most people are failing in terms of section 24 and 25. So next slide.
So final question, final poll for the day about section 24 and section 25 access. Is there a difference between gaining access under section 24 access or section 25 access? Is there a difference? Give it another minute. You can see the results are still coming through. Okay. Most of you have said yes, there is a difference. A few have said no. So I'll pass back to Loretta to go through this.
There shouldn't be. That's the simple answer. This was recent, and the reason that I asked that particular question, and just go to the next slide. Sorry, Catherine, I'm losing my voice. Oh no, back.
This is.
All right.
This is the slide.
Yes. So there shouldn't be. The difficulty is that we think that there's policy guidelines that the NDIA have produced that means that people who gained access under 24 or 25 are treated differently. The difficulty is, and we've been asked this question about whether a person having gained access under 25 can then go back and ask for access to be given under section 24. We think that might be an issue that could be novel and complex. My view, though, is that the problem is section 21 of the legislation says you can only, well, the legislation says you can make an access request if you are not a participant and you're not in the internal or external review stage. So I don't think this has been decided. It certainly hasn't been decided in the AAT. The issue is that once you're in, can you then go back and make another access request? I don't think you can. The problem is when you get to making your plan, what needs to be argued at that stage is that your reasonable and necessary supports should not be dependent on whether you gained access under 24 or 25. We understand that because of section 25 access, the operational guidelines and policies of the NDIA, even though we haven't seen them as such, limits the reasonable and necessary support that the child or person receives. Now, it's clear that the legislation provides that there might be different supports provided for a class of person. There's capacity in the legislation to make rules about that, but they've never made any rules about it. So, in a sense, I don't think that should be treated differently. It's the sort of thing where I think you need to, if you've got under section 25, you don't think the supports that have been provided are reasonable and necessary, then the question is you need to go and ask for the internal review based on the fact that the supports are not reasonable and necessary, and then if you're dissatisfied, to go to the AAT. And that might be the stage where the NDIA might say, well, we treat these people differently. And it's a question then of going back to the legislation and rules. The legislation does not provide that we can see all the rules that a person should be treated differently depending on how they've gained access. All right. I might answer the rest of the questions in a minute after we do these final things. So the things that you really want to watch out for is the person close to their 65th birthday? Because if it's after their 65th birthday, you're out. Now, what happened in, we recently had to give advice to a person, I might talk about that in what a hearing de novo means in a minute. Was the access request refused because of section 21(3)? That's where the CEO or the NDIA didn't make a decision for some period of time. They didn't make a decision for some period of time. In that particular case, you have 28 days from the date a decision is made to go to the Administrative Appeals Tribunal. There is an argument that if the CEO doesn't make the decision and it's an automatic thing, so you might not even know that a decision has been deemed, and the NDIA could argue that you're out of time if you try to make the application to the AAT. I would seek legal advice about that, obviously. The thing that you really need to do is think about the adequate medical evidence supporting the access request, because that seems to be a big issue. Review, making sure that, and again, when you review the request, that is supported by adequate medical evidence, that you make your application to the AAT within the 28-day time limit. Having said that, though, one of the things, there's been a few decisions. So when you have a decision of the NDIS, NDIA, you only have 28 days to appeal to the AAT. Right? So recently there was a case where a person waited 4 or 5 months before they made their application to the AAT, and the NDIA argued that the person really needed to start the process all again because they were out of time. In that particular case, the AAT actually said no, there was no prejudice to the other side, and because the person was able to provide reasons as to why they didn't make the application in time, the application was still heard. So just because a person is out of time, don't just say you can't go to the AAT. They really do need to get some legal advice about whether they can go to the AAT and what you might have to put into the request when they go to the AAT as to the reasons why there was a delay. There is an issue about the other issue, though, is that once having gained access, people are not getting their plans done, so or written up in a timely manner. In fact, there's 2 issues about delay with the NDIA. One is that once you've got access, you don't get your plan, and once you have your plan and you've asked for a review, they don't review it in a timely manner. If you have a plan and the NDIA does not review it in a timely manner, that decision or lack of a decision is not generally appealable to the AAT, all right? Because you need a decision and you don't have one. But the AAT in a recent case said that they did have jurisdiction. They were able to hear a case where a review hadn't been conducted for a period of 9 months because they said even though the legislation doesn't specify a time, there is a time as to what is reasonable in responding to a request for an internal review. However, with plans, so you get access, you don't get a plan issued. The issuing or not issuing of a plan is not in and of itself a reviewable decision. We have recently been asked where the person had waited 6 months or something for a plan to issue, whether they could go to the AAT. Our thinking about this is, our initial thinking about this is that you can't go to the AAT, but you might be able to go to the federal court. I just want to put in a note of warning about this, because to go to the federal court would probably take anything from 6, 12 months, 18 months to go and do that. So you'd only want to do that in one case, to actually try and force some changes to the way in which the NDIA deals with these matters. You wouldn't want to have everybody rushing off to the federal court, because the federal courts is a cost jurisdiction, and so you don't want to do that, unlike the AAT where there's no costs can be awarded. So you want to be very careful about the sort of case that you would take to the AAT. So the question that I was asked, there was another question that I was asked in relation to the Gympie rollout. Once NDIS rolls out in the Gympie area, will there be a waiting time of between 6 and 12 months before some plans are completed? I've got no idea, because obviously we're not part of the NDIA, but there is an issue as to whether you apply to the AAT if there's a delay in issuing plans. And so our preliminary review there is that you would need to apply to the federal court, but really you want to seek advice if you think the plan's taking too long to develop. And this is particularly, and I think you can't say a plan should be developed within a month. You can't say 6 months is too long, 1 month is fine. It just depends on the person and the circumstances and the urgency that's attached to the request. The other thing that I wanted to stress with you is that if you do go, say the agency has decided to knock you out on the basis of reduced functional capacity, they said, no, you don't meet that criteria, and you go off to the AAT. At the AAT, it's a hearing de novo. What we mean by that is that the AAT can look at the whole application. So you might be able to produce the evidence that there has been a reduced functional capacity, but they might then say, well, you don't meet the permanency requirements, and the AAT could look at that. I just got a question, and I absolutely agree. What a litigious nightmare. It is difficult, but it's also simple, and I think it will get easier over time. I know that there are a lot of people who are getting in, and there's no problems. These are just the proportion of claims and matters that are coming to us, and they're always going to be a small percentage, and they're always going to be the more difficult ones. So I don't want you to think, oh, this is all too difficult. I just want you to think about these things when you're supporting people. Now, there's a few questions on here, and there's a few other questions that we haven't covered. So I might get Catherine to ask me those questions first, and then, because I've got the answers to those, and then she can ask me the other ones, because I'm sort of losing my voice, as you can tell.
Yep, and just if you have downloaded the handout, you'll be able to see office locations near you and our contact information as well. All right, and that handout is titled Legal Aid Queensland NDIS Unit for Workers Only. So if you haven't downloaded all three, I'd suggest you go and do that now. We will go slightly over time, so we just invite you to stick around for an extra 5-10 minutes while we cover off the last few questions. If you've got a question of your own, now's a great time to pop it through. All right, Loretta, so someone's interested in how they can support a client to review a decision or lodge an appeal. Are you able to touch a bit more on this?
I think the best way to support somebody to lodge an appeal is to make sure that you've read section 24, 25, the rules, and that the medical evidence will support that request. That's the biggest thing.
And
and that you also access the disability advocates. And you should be able to get the disability advocates just by going to the NDIA website and putting in disability advocates, and the organisations should pop up.
Thanks, Loretta. And will support coordination be an ongoing line item of support to participants?
No idea, because like I said, I'm not with the NDIA. However, I know from personal experience that it seems that they will only give support coordination for very complex cases, and for other cases, they won't give it if there's a local area coordinator or an NDIS office. This is again a question of when you think that support coordination is required and it hasn't been included in the plan. That is something that you could ask to review as a reasonable and necessary support.
Thank you, Loretta. Can we just touch on age requirements a little bit here and residential aged care facilities? What process is required for people who are less than 65 years to go to residential aged care facilities on a permanent?
Yes, I'm not sure what the question is asking here. So this was put in before, before this presentation. But I suspect the issue is when you can't find accommodation for somebody and the only option is the aged care facility. Look, this is difficult because we know that there's a lot of people still remaining in aged care facilities. I think I heard something the other day, there's still about 6,000 people in aged care facilities, people with disabilities who are under 65. I mean, I think the NDIS is really trying to ensure that people don't go to an aged care facility, but it might be the only option. I really don't think I can add anything more.
Mm-hmm. And so, Loretta, someone said, you mentioned that advocates are only available after the NDIS plan is in place. Can they therefore provide support for appeals that are rejected?
Yes. So as soon as an access request has been refused and the person needs help making an internal review request, they can access the disability advocates. Only legal aid is only available once they're in the AAT, and again with all those criteria. But that's why we've widened out what we will do in advice, because we're very conscious that there are a lot of legal issues that a person needs to think about when making an access request.
And just, Loretta, looking at mental health again, what happens when a mental health condition is caused by the treatment that causes additional, not only mental health, health in general, what happens when the health condition is caused by the treatment that causes additional disabilities that creates and affects functional impairment?
I think the issue is it a disability that's, the question is it a disability that's attributable to those sections within the legislation? I think it's, if you go back and have a look at section 24(1), and I'm going to flick my papers because I've actually got it written down here. The person has a disability that is attributable to one or more intellectual, cognitive, neurological, sensory or physical impairments. It doesn't matter whether that's been, obviously, if you can show that is an impairment that they have, it's got the permanency and it results in a substantially functional capacity, that's relevant. Can I just make one point about substantially reduced? It's not that people have more difficulty. So one of the things that is somebody, it's slower for them to, learn more things or to communicate. That isn't in and of itself going to be enough. It has to be a substantially reduced functional impairment. So it's whether they can do it, whether they can only do it with assistive technology, or whether they can do it with somebody only with the assistance of another person, or whether they can't do it either with the assistance of another person or assistive technology. That's the test as to what is substantially a substantial reduction, and you need to look at a Rule 5.8 in relation to that. So one of the things that I'm thinking about, so in mobility, the fact that you can't drive, it may or may not be substantially substantially reduced functional capacity, because there are a lot of people in the community that can't drive. But and that may not be enough to show that you have reduced functional capacity and mobility, or substantially reduced functional capacity and mobility.
Mm-hmm. We've had a couple of questions about plans, so I might read two of these out. What would be some reasons why participants are being denied access or copies of their plans? So this person is specifically looking at participants who don't have access to the internet or to the NDIS portal online.
I don't know. You'd have to raise that with the NDIA. One of the things that you can do is, if you're unhappy about the processes within the NDIA, you can make a complaint to the Commonwealth Ombudsman. I'm not sure how they're dealing with those complaints, but that is about the process within the NDIA, and I suggest that you go and see them. We did have a case where a person had asked for, I mean, it's really difficult because some people who are trying to access the scheme have an intellectual impairment and no support. How are they going to be able to understand the processes and the information that's been provided? It is extremely difficult, and it's not, yes, there are local area coordinators, and yes, there are disability advocates, but how do those people get access to those? And also there is already, you know, some capacity issues even with disability advocates who are just being swamped by the amount of you know, appeals that are coming before them.
Thanks, Loretta. Just going back to what you were saying about if you're unhappy with your plan, you can talk to the Ombudsman. Someone's wondering, can they do that after their initial planning meeting? And should they be requesting a review of the plan or an internal review request?
Okay, so this is really important. What you want to be requesting, and this is really about reasonable and necessary supports. If it's within 3 months of the plan, you really want to be requesting a review of the reasonable and necessary supports in the plan. The reason for that, if it's a change of circumstance and it's after that 3-month period, then the only decision, like the decision that's before the NDIA and that you can go and appeal to the AAT, is whether they agree to review the plan or not. It's not a question of what the supports are in the plan. Now, in the past, the NDIA has tried to treat any objection to the supports in the plan as a review request, which therefore had the effect of limiting people's ability to apply to the AAT. I think that's sort of, they're getting it a bit more right now.
Okay, thank you. Someone would like to clarify what you were saying earlier.
No. So am I understanding that if a person that has impaired cognitive function and granted NDIS, should the LAC assist with the implementation of the plan? Yeah, well, that was my understanding. So not Legal Aid Queensland I was reading the local area coordinator. That was my understanding, that the local area coordinators are supposed to be helping people to do that support connection if they don't get support connection or support coordination in their plan. But, I mean, yeah, that's the way that it's been explained to me.
Thank you. And one more about plans. Someone's heard that participants cannot have access to their plans if they're under the public guardian, but if they're under the public trustee, they can. Otherwise, QDN say they should have access. Do you want to make any comments on that, Loretta?
I can't really make any comments about that. Once you have a guardian appointed, you know, you've lost all your, you don't have decision-making powers. So it's probably appropriate that the public guardian do have that information. The problem that I see going forward is that there might be more of a push you know, this has been a very informal system of particularly families helping out people with the disabilities, and sometimes that can be good, very, very good for the participants, but in some cases it can be a negative impact. the problem is that if it becomes too difficult to navigate the system, a lot of the times there'll be more of a push. Well, we're just keeping an eye on whether there'll be a push to have more guardians appointed for people with a disability, which I think would be a terrible outcome. But we'll have to keep looking at that.
Should the public guardian pursue a review or appeal on behalf of the participant or refer to the disability advocates or LACs to support them in this process?
Well, I think the public guardian, if they are appointed as that person's guardian, they can make a request for a review of the plan. I don't know so much about the public guardian, so I can't say anything more. But again, the ability to access the disability advocates is what their processes are, and I'm sure that they're about capacity as well, and legal aid as well, that the issue is not about who is the person's representative. The issue is about whether the matter is novel and complex.
Thanks, Loretta. We had one more question that was asked before the webinar started, and I think this might need to be the last. I know you were touching on pros and cons earlier, but this person's wondering, what are the pros and cons of the NDIS in general?
Oh, gee, I didn't even see that question. Oh, look, I think it's delivered some great services to some people, and it's left other people with gaps. And this is why this legal process is so important, because we can address some of the legal issues, and hopefully people will be able to get greater access in the future. So I see it both. I see it as a positive thing. I think for people with a disability, but there are gaps that have been created, and we need to make sure that the NDIA is applying the legislation. All right.
Thank you. And I know you've gone through a couple of tips just now, and you did have your tip slide, but do you mind leaving the audience with just a couple of key points just to wrap today up, Loretta?
It's really important to make, it's really important that if you think the person should get access, that you have proper medical reports, and that you make sure you make the access request. If you're not happy, you go through the internal review process, and you get legal advice and the support of disability advocates if you need them.
Thank you. Thanks so much for presenting today. I can see by all the questions that everyone's learned a lot. I know I have personally too, which is great. And I'd like to thank the audience for your questions and for listening in today. Our next webinar will be in October, and the invite will go out shortly, so keep an eye out for that as well. Thanks, everyone.